Thank you. Good morning. Can I ask you to stay ready for trial?
Yes, Your Honor.
All right, Mr. Weeks, are you ready for trial today?
God bless you, Your Honor.
You will. Okay, are you ready for trial?
I don't have any other option but to be ready.
Well, you do, and let's just be clear about that. State the offer, pre-trial was?
It was a withholding court cost, $50 investigative cost to St. Pete.
So that's your other option if you want to take it, would be a $550 fine. Again,
I would have wanted to know about that before the day of trial, by the attorney that you keep insisting is on standby, that way so I can talk to God about it. I've told you this before, I need to be able to talk to God about everything.
right, it was communicated back in April of last year. It has been since, for what it's worth.
So you mean, this is the one I've already addressed, actually.
Well, this is the trespass we're talking about. So, but to your
referring to
point,
the
you said-
offer.
No, the offer's the same as it's always been.
Oh, then I mean, it's the one I've already addressed.
Right, but you can
And
change your
the
mind.
answer is the same.
Yeah, you do not wish to accept that offer? I'm not saying you
It's
should or
the same
shouldn't.
as how I addressed the last time.
Okay, so are you ready for trial then?
Your Honor, I addressed that just a moment ago as well.
Okay.
I
Well,
do
no, you said you
appreciate-
have no other option. I
That's
told you
right,
you do
and
have
I
an
have
option,
to be
which is-
ready.
Which
Yes,
you can plead, so you can either accept the state's offer, or we can go to trial. So you do have another option, and that is to accept the state's offer. I'm not saying you should or shouldn't, but I just want you to know you do have another option. So which of those two options do you wish to take?
Your Honor, I did make it clear just now, I'm not gonna accept the offer
Okay.
because,
That's fine.
I wanna be able to focus on God.
Okay. Mr. Nasty?
Your Honor, I do have copies for the defendant and standby defense counsel of the expected exhibits that we are planning to enter today.
Why am I just getting evidence?
Well, I don't even know what it is. We're gonna talk about it here. Mr. Nasty, what is
Do you
that?
think that's fair, Your
I
Honor?
don't know what it is. Let me find out.
Actually, I'm not referring to what it is actually, but do you think it's fair that I'm just being presented this?
Well, it depends
the day
on
of
what,
trial.
it is. So, Mr. Nasty, because if it's a map, by way of example,
As
or
she's
something along
referring
those
it
are,
to be the evidence that she's gonna use
I
today.
don't know what let's hear from her and hear what it is. Mr. Nasty?
If I was just presenting evidence, would I be able to use it today?
It depends what it is. Let's,
You last
I don't
week,
know.
you made that, you
Mr.
made that
Nasty,
clear though.
what is it that, you just gave Mr. Hicks and Mr. Montrose?
Your Honor, one is a copy of the video that we plan to introduce. That video was previously discovered over back in 2021.
Okay.
It's just the edited version we spoke about on Friday.
Okay,
Another one is a map that we did request, Your Honor, judicially notice.
okay,
And then the third is a public records document, a special warranty deed, just indicating that Pinellas Suncoast Transit Authority does own the plot of land where this did occur. It is a public record that has only been discovered over on the 14th of March. However, it is a public record. It was available for anyone to be able to view and know before this time.
all right, so before we talk about that, one of the things, Mr. Hicks, and I know you said what your answer is before, but as I said, I have to ask this question at every stage, so I'll be asking you multiple times today, which is, do you still wish to represent yourself?
Well,
Or do you wish Mr. Montrone to step in and represent you?
does Ms. Martrone support my attempts to assess why you're complacent with the way things have gone in this trial?
I don't know.
I have a faith-based defense. Is he going to, protect my religious freedom even in this courtroom?
I don't know.
Oh,
Well,
well,
I can
if you
say-
don't know, then if you don't
I can't
already
speak for
know,
I can't speak for Mr.
then
Montrone.
no.
Okay, fair enough.
If he,
So-
because my religious freedoms, they're just rights, he's an attorney,
Right.
that should be a given, that answer.
But I can't-
Should be a
well, I
given
can't
from you
speak for anybody else.
that he'll uphold the law, as I would need him to. I've told you this is why we're here today, because public employees, aren't the least bit concerned with my religious freedoms. You know that, and you've made it clear how you feel about that. And as well as, the state deliberately filing a motion to prevent me from, just telling the jury in basic form that I trust God with the outcome of this, these proceedings,
Well, I'll make myself clear before, now let me make myself clear again, which is I have no opinions about your ability to have the free exercise of religion
Yes,
at all.
you do.
And, okay, I guess I
Even
didn't-
especially in this courtroom.
So,
You
but
gave
what I'm
an
saying,
opinion on
what
the
I'm saying
state's
is that
motion to
you can
limit
exercise, you
my
can practice your
faith-based
exercise,
defense.
your religion as much as you want within the confines of the law, of course. However, you cannot argue for the jury to throw out your case on religious grounds. You just can't. It's
I
not-
never would. However, the state
Well, that's
is
what they're
trying to,
That's what their motion limiting was to make sure that you can't ask for a jury pardon and discuss, whatever the motion limiting was, that I.
Actually, Your Honor, they made it very clear, they even quoted me
Yes.
in
God is
even
using the
these
situation to
proceedings.
identify the culture and atmosphere among public agencies that allow my rights to be violated without due process. That's your,
And Your Honor, if God tells me that I need to present that information in my defense, that's what I need to be free to do.
Okay.
I need to be free to tell this court that God picked me to stand up to public employees that would use their agencies to violate my religious liberties, just praising God on the way to church while riding the bus. If God tells me to tell the truth, that's what I'm going to do. And and you've accepted the state's motion to deny my ability to say that God is in control.
okay, well, what we're here to, what the jury is here to determine is whether or not you committed the offense of trespass or not.
I understand that. I'm referring to the fact that this court is being used to violate my religious freedom.
No, I disagree with that.
I am saying I do know that, and I have a right to, in fact, get that information from God.
Okay, well, if you want to say that, you can say that. Doesn't mean it's true now. Then feel free to say it.
Actually, God is not a man that should lie.
What's that?
God is not a man that should lie. He does not make any mistakes.
Okay.
He's perfect in all his ways.
Okay.
And I trust him like I've trusted him to conquer every serious issue I've dealt with before today.
Okay.
That's why I can stand before you confidently. Being able to accept even the worst punishment that you would throw at me for practicing my faith in a public space, on the bus, and being willing to, go
Now,
through this.
to be clear, that's not what the trial's about. The trial's about whether or not you've been trespassing. And if
I
there is a
have the
sentence-
right to go to God and ask him what this trial is about. I
Okay.
do respect your right to tell me that I may not be able to express that in certain ways, and I'm going to do that, So for now, we're going to go ahead with what you plan on doing, you and the state plan on doing.
Okay.
And, you're going to watch me trust God, even when you do the worst that you can.
Okay, so let's call up 26 jurors, deputy, if you please.
No reserves?
Now, just to be clear about one thing, and I've said it before, I'll say it again. Mr. Montrone is on standby. If at any point that you want him, or you want to consult him for advice, you can, okay? If at any point you want to terminate your self-representation, you can. It doesn't have to be when I ask you, if you want to. I'm not saying you should or shouldn't. We've already gone over that. But I just need you to be aware of the options that you have. So, Mr. Montrone will be sitting there, uninvolved, I should say, unless you want him to be involved, just for understanding each other. Now,
So you're not cool on what time?
well, we're not that much further out, so maybe up in 30 minutes, 10, 15?
It's possible.
Okay,
10, 15.
Is
so,
it possible that I may have a little bit of time, to use the restroom?
yeah, of course,
and grab a bite?
that's 30 minutes. So, you can,
26.
there's that cafeteria downstairs, obviously, as well.
Mhm.
If there's any potential jurors, do not talk with them, and that goes for the state also, it's not just you, Mr. Harris, anyone who's involved in the case.
No reserves.
All right, anything we need to discuss,
Yes.
Mr. Montrose?
Two things, Judge. Housekeeping matter is, just to remind you that I have a DMV hearing at 2 o'clock.
Yes,
If I could just go in the back, I should be able to take.
sure,
care of
just
that.
remind me again around then in case I forget it, so
Right.
we'll plan accordingly.
And the other thing is, before the court hearing last week on this matter, I did attempt to speak with Mr. Hicks. He didn't want to go out in the hallway to talk to me. During the hearing last week, you asked me to give him my contact information after court. I walked outside, he was walking down the hallway, I called out his name, he turned around, looked at me, and kept walking. I went downstairs, I saw him again, I made a second attempt to contact him, and he essentially walked away from me.
Okay.
I did receive the supplemental discovery from the state on the 14th via email. I don't have any contact information for Mr. Hicks. I did have a number in our software. I attempted to contact that number so that I can get him the information that I had received. The number was disconnected. This morning I printed out the charging document, jury instruction, the motion to eliminate, all the supplemental discovery I had received, and I handed to Mr. Hicks this morning.
Okay, and are you available if he wants to talk to you still?
Well, I'm standby counsel. My understanding of that role is if he has any procedural questions while the trial's going, I'm at his disposal, but I don't make any tactical or evidentiary decision for him.
So if he's there, if you need to talk with him some more, Mr. Hicks, Mr. Nassi?
Your Honor, may I ask, is the defendant wearing a shirt that says Jesus on it?
He is.
May I ask that that not be presented to the jury?
He's, that he's allowed to wear, you know, yeah.
Yes, Your Honor.
It's not overly offensive or any thing along those lines.
Your Honor,
Yes.
that was a direct attempt to limit my religious freedom.
And I said you can wear it, there you go.
But Your Honor, I am concerned why she believes she's free to ask you. I mean, if indeed she doesn't even know my basic religious freedoms in this court, how would I be expecting her to properly adjudicate the charges against me?
Well, that's for me to rule on now at this point, because.
She has an obligation to know the law
Sure.
before charging me, and especially when it comes to my religious freedoms.
Sure.
She heard me just have concerns with all the attorneys, you know, about my religious freedoms, and yet she still feels free to ask me not to wear Jesus on my chest.
Well, there's a body of case law about clothing that can be used to communicate messages to jurors and whatnot, but
But you know, this
I'm
is,
saying
she knows, she directly asked you about Jesus.
Okay.
You know, she's,
Well, it's just like
but Your Honor, you know she went through law school. And I know that you know whether she should know.
Okay. Well, I denied the request, so. All right, so Mr. Hicks, like I said, yes, you can use the restroom, grab something to eat if you want to make sure to be back here in the courtroom by 10:15, okay? Anything else we need to discuss? Oh, in terms of motions, so.
Yes.
I'll rule on that.
I have something I did want to discuss.
Okay, go for it.
You first.
Be first, okay? What about me?
Discuss what you want to discuss first.
Oh, it was gonna be about the discovery, or what you were handed. So one is the redacted video that was discussed during the motion and eliminate. If you need to view that. You don't have a laptop, do you? Does it play,
DVD.
Ms. Tenassi can make that available for Mr. Hicks to watch if need be from the state?
Yes, Your Honor.
All right. So Mr. Hicks, if you need to watch that video to verify that the redactions have been made, we can do that. We'll just be done here in court without the jury here. That's the first thing. As the second thing, well, hold on a second. Let me just give over the next two. And then
Yes, go
I'll
ahead.
speak.
Sorry.
And that's okay. And then the other two are the request for judicial notice. One is a photo of the area that you've been provided, and the other is the I suppose the public record ownership plat that are within the property appraiser's website or something along those lines.
Why is
they
that
intend on doing.
relevant, Your Honor? Especially understanding that, the original trespass complaint you and the state have argued isn't relevant.
Right.
So why is it relevant that, the PSCA, we've all along? I think it's maybe because
Well,
in the original trespass complaint, the police coordinated to let them know that they don't, to tell me that they don't own it.
Well, I'm not making a call on it just
Are they
yet.
trying to clean that up? Is that
I don't know.
why? I mean,
So
because, the original trespass complaint and video is not being admitted in this court.
Correct.
I mean, why do you think that that's okay
Because
even
it's not-
even though you know the truth lies in there.
Well, because the charge is not that you were trespassed, it's that after being
It
trespassed,
was.
that they're that. And if there's a
Yes,
fight
the
to
charge
be
is
done-
that I was trespassed.
Well,
They
then-
want the jury to believe that I was lawfully trespassed, and you directly told me that you don't want me to insinuate that the truth is that I was not lawfully trespassed, and that I was actually, my religious freedoms were
see
violated,
law-
just like how they were in this court. And I've told you that many times.
Yeah.
All I'm saying is that, you know, the original trespass, the video from that is publicly available, and you've insisted that none of it be admitted.
Right, because it's not relevant, and here's why. It may be relevant
The
in your life.
truth will expose that they
If you-
trespassed me and told me they don't have to have a reason.
Okay,
Your Honor,
if
the
you
truth
wanted to
is
find-
that I was on the bus and they made me get off at that specific location
Okay.
so they can trespass me there.
Well,
And the
if you
state
want to
fully
find
knows
the
that I
PSTA,
continue to
before you
ride
can.
the bus from there, you know.
But if you wanna
Since
find the
then.
PSTA, or
The
PTSA,
PSCA has continued to take me there to that location, to and from, and also even inviting me to drop out the information for the social programs that they've approved me for. I have proof that I visited, in fact, the state knows that the PSCA, Suncoast, Transit, they can digitally provide the state with how many times I've ridden to and from that location since I was both trespassed and arrested.
Well, they
Why
have
is
to
any
prove-
of that being admitted?
they have to prove all the elements which we gave you the jury instructions beforehand. If you believe that you entered on or remained in the property with authorization, license, or invitation from that, well, you can argue that if you want. But I'm not telling you you can't argue that. What I'm saying is that the original
You did say I
trespass.
could.
Well, what I'm saying is that the original trespass is not relevant because that if you wanted to fight them over that or sue them over that, that'd be in civil court. Once
Your
it
Honor,
gets to yours.
that's not what I'm referring to. I'm
Okay.
referring to the original trespass,
Right, right.
clearly indicating that I was invited to that location by the bus driver. And
Okay.
you know that you were deliberately trying to convince me that we shouldn't tell the jury that I was invited to that location by PSCA.
On the day you were arrested or on the day that?
On the day I was trespassed and the day that I was arrested.
Well, it would be
They have
not
been-
relevant to the day that you were
But
trespassed, but
the
it could be
state,
relevant to the day.
has that information. They know that I've ridden to and from that location since I was trespassed and since I was arrested. And there's a whole year in between then.
Okay, well, again,
And yet
I'm
they-
not preventing you from arguing on the date of this offense.
But you know the state is fully aware that the company that trespassed me has continued to invite me to the location I'm being charged with
I don't know.
trespass.
I don't know. But bear in mind, you still have to abide by the rules of criminal procedure and statute, so the evidence still has to be legally admissible to come in. I'm just saying that, so.
You made it so the state can feel free to curtail my religious liberties in this court, just like
No.
PSTA. They filed a motion, to limit me being able to wear this shirt, Jesus.
And I'm saying you can wear it.
And even though you told me I couldn't previously with the
About a shirt?
motion,
I never said you
yes,
wore a
you
shirt.
did. You made it very clear that I cannot have a faith-based defense.
Well, that's true, but I'm not saying you
This
can't.
is me wearing this shirt, you know it's a part of that, and yet you
I'm saying you can
know
wear
that they cannot.
Well,
they
wearing
don't
a
have
t-shirt is not a
compelling
legal
reason
offense,
to
it's an
keep
expression
me
of whatever
from
you
it.
wanna, you believe it's an expression of your religious faith to wear that t-shirt, I'm saying that's fine.
Mhm.
All right, but that's different from arguing something to a jury, that may be illegal. I don't know. if it's
That
illegal.
God is in full control and he picked me.
Okay, well, we'll see what happens. So,
But, Your Honor, you said, the state's motion that I couldn't. You did approve that, and I'm directly telling you that it's not a compelling reason to curtail my faith-based offense. The state argued that they were just worried the jury might be confused about
Well,
my
what they
faith.
said, just to be clear.
Yes,
they
that
said
is a
any-
word, confused, that she used.
What I said was any interjection
I'm
of
referring to the
personal
state.
opinion in the defendant closing argument, that I did not grant, I reserved on that, so.
You did grant it.
I'm almost positive I reserved on that, Ms. Tenassi, what do you have there?
Oh,
A
explain
motion was
reserved.
verified.
Explain reserved the motion.
Means I haven't ruled on it yet.
Curtailing my religious freedoms.
So number 5, I think I reserved, well, I granted with, what did I do?
Your Honor, you did say just no improper arguments.
Yeah, which is what the law is, right? But, so, yeah, reserved on 5, which means that you can't make any.
Are you saying you didn't approve of them trying to, limit my faith-based offense?
What I'm saying is that, I ruled on number 1, 2, 3, 4, and 5, I granted 1 through 4. As to 5, any interjection of personal opinions by the defendant closing argument, I reserved on that, saying that you cannot make any illegal arguments, which is what any lawyer making any argument, has to.
What does that have to do with faith-based offense? In fact, Your Honor, I just told you, God is not a man that should lie. If I get something from God, if God tells me to do something, it's not gonna be a lie, and I don't appreciate you trying to misconstrue that into, something run-of-the-mill like,
I'm not trying to misconstrue anything.
dishonest arguments. Your Honor, I'm referring to you being dishonest about the fact that the state knows they've been violating my religious freedoms by just simply asking you whether I'm wearing this shirt. And you assist them. You should not have even answered that question. You should have shut that down.
I did. I said you can wear the shirt.
Your Honor, you weren't even. Your Honor, if you know what, if the original public employees had protected my religious liberties, this proceedings wouldn't be such an undue burden on the Sixth Circuit.
Well, and if you wanna sue the PSTA for violation of your religious,
Your Honor,
religious.
that's not what we're here
that's
for,
a
Your Honor.
different thing. I agree.
We're
it's
not
not what
here
we're
for that.
Yeah, I agree.
This is what I'm here for. It's just to stand up for the truth,
Okay, well, it's a trespass, just to be clear. So, but that being said.
What's wrong with me being truthful about this trespass? I've directly told you and everyone, including the arresting officers, that I know I was trespassed. This court knows in fact, the state knows I haven't been trespassed just once, but more than one location for this very same reason.
I did not know that, but that doesn't.
And yet they won't admit that. Your Honor, I've directly told them that I continue to go to that location, that the bus drivers continue to take me to and from that location, and the state knows, and they have a duty to at least verify whether PSTA employees that have been continuing to invite me to that location. In fact, even the security guard, Malik, I've seen and interacted with him multiple times since I was arrested that day, and the state knows that. And yet we're here today knowing that the PSTA has continued to invite me to property to use a public service that I told them I have a right to. I told them that I have a right to be at the location I'm being charged with trespassing, and I don't live with that even today.
Okay.
And yet, Your Honor, you're insisting that we all be okay with why we should know how that factors in.
What I'm saying is that the state charges
To me being
trespass,
charged
that's what we're here for
when
today.
they know
We're in trouble.
I'm invited there all the time. They know that PSTA wants me to be able to ride the bus with respect from that location. And yet, what gives, Your Honor?
Well, just to be clear, the jury's still coming up, and I said you wanted to break and grab something real quick. The time's ticking still, so I can't answer any of your questions because we're here for a trespass charge, and that's what I'm here for.
I'm here to stand up for my religious freedoms, and I was hoping you would provide me with equal protection under the law, but
We'll always
that's
do
not
that.
who you are.
Okay, well, I disagree, but there you go.
Your Honor, we made it to trial because you won't protect my religious freedoms.
Okay. That's not why we are here, but okay.
Yes, that is, I told you, Your Honor, what information I get from God, He's not a liar. I have to, again, and that's why I don't want you trying to convince me of a lie. I'm not
trying to
trying to
convince
see
you
you.
of anything.
If I get some information about you from God or in the state regarding why they feel free to curtail my religious freedoms in this court, you know, it's not up for debate, and I need you to respect my religious liberty.
All right, well, if you get information from God about me, let me know.
No,
Okay.
you need to go to God yourself. If you want to know something,
See what I can do.
you need to go to God. Your Honor, I want you to go to God about me.
Okay, well, we're gonna have trouble then. So feel free to, like I said, 15 minutes is what we got. Okay?
All right.
So, again, you're free to move about the courthouse if you like. We'll make sure you're back here at 10:15, okay? Okay. All right.
Judge, we're like,
Over there is good if you want to, we can, look something if you need to. All right,
Taylor.